This is Open to Debate. Hi, everybody. I'm John Donvan, and I am delighted to be joined once again by our Chief Content Officer, Lia Matthow.
Hey, John. It's so great to be here.
It's great to have you back on the program, Lia. And this is another in what we call our Think Twice series, and that is when instead of bringing you a debate, as we most often do, we bring you a conversation around issues that are related to debate.
And it's a way to go deeper on some of the issues that matter to us at Open to Debate. And this one is a very special interview.
Indeed it is.
It's a sit down with someone familiar with hearing all sides of a contentious issue.
You're keeping us in suspense.
Former Associate Justice for the Supreme Court, Stephen G. Breyer. He served on the bench for 30 years from 1994 to 2022.
He is what in the TV news business we would have called a major get. So we're really we're so excited to have him. Also, the Supreme Court for us at Open to Debate has really been a particular focus with so many cases being handed down over the years that have real life consequences for people. And very often these decisions are right in the middle of important cultural and policy considerations that we like to debate.
Executive power.
Right. Abortion rights.
Free speech.
Second Amendment, debates about guns, gun rights, things like that.
Yeah, we've covered them all. And this particular conversation also relates to a debate we did just a few years ago. We asked, should SCOTUS, the Supreme Court, focus on the original meaning of the Constitution?
And how does Justice Breyer come down on that question?
Well, it's something he feels pretty strongly about. He's asking us to rethink textualism, which he's been arguing against for years.
In fact, it's the subject of his most recent book, which is called Reading the Constitution, Why I Chose Pragmatism, Not Textualism. We'll be talking about the philosophy he uses when he weighs in on decisions. And we'll look at some of the particular arguments that he was involved in by looking at some cases, some of the most high-profile decisions of the past couple of decades.
And even more, he'll take us behind the scenes, a peek at how the justices get together and make their own decisions behind closed doors.
And I haven't heard that before, the curtain pulled back the way that he shared with us what they do as justices when they're not walking around in their robes, but actually just making decisions.
Fascinating.
And for this one, we went on the road. We went up to Harvard Law School in Cambridge, Massachusetts. That's where Justice Breyer is currently teaching to have this conversation. So we will be showing up in Cambridge for this, but also occasionally we're going to be breaking in to come back here to the studio to provide bits of background and context.
Yes, John. So let's get started.
Justice Stephen Breyer, welcome to Open to Debate.
Well, thank you very much for inviting me.
We're so pleased you're with us today, Justice Breyer. And I thought we would just start by asking about the premise of this book, textualism versus pragmatism, some definitions, and what's at stake, and why did you write this now?
I think I wrote it because a method came along of interpreting the Constitution and interpreting statutes. That's what we do. We in the Supreme Court will hear a case, because we don't have to, but we'll hear a case almost always when the lower courts have come to different conclusions on the same question of federal law. That's a statute of Congress or the Constitution. And that's what we do.
Why is the world set up in a way that they would come to different conclusions?
Well, because you have the freedom of speech. And that's why you have judges who have to answer the questions of the scope of the statute. And to go back to the book, when I want to know how do these words apply, it's traditional. There are traditional ways. And someone said, Scalia particularly, we used to debate this. We used to go to colleges and law schools, and we were obviously good friends, but we didn't have the same view.
So we're going to break in here for a moment. Nino, he referred to, is actually Supreme Court Associate Justice Antonin Scalia. That was his nickname.
Yeah, and so this tells us that Justice Breyer and Nino, Antonin Scalia, Justice Scalia, and he were actually really good friends, though they disagreed on a lot of things.
Yes, and one of them was textualism.
So I forgot something important that I wanted to mention about Lia. Lia, you are our head of content. You're a career journalist, but you also have a law degree.
That's true.
So maybe you can help clarify for us some of the terms that Justice Breyer is using in this conversation. Three of them: pragmatism, textualism, originalism.
Sure. Reliving my con law days and, of course, Justice Breyer's book, I'll give it a shot. Pragmatism is a theory of interpreting the law that Justice Breyer suggests the court use
And in his words, he's trying to understand the purpose, the intent, the impact of the law, and create an opinion based on all of those considerations.
And how does that differ from textualism, pragmatism versus textualism?
So textualism is about looking at the text and the meaning of the words on their own, as they would have been understood at the time they were written.
Okay, that's textualism. Originalism?
Originalism is similar, very similar to textualism, but the latter emphasizes historical context a bit more. It's related to the law or the constitutional provision. It considers what the intent was at the time of the adoption. So they're close cousins and sometimes conflated, but legal experts note the fine distinctions, and both have become very popular. And a case for a return to pragmatism is what Justice Breyer's book is all about.
And Justice Scalia was which of these?
Well, very influential justice, on the record as both a textualist and an originalist.
Okay, so the Justices Breyer and Scalia, as we've said, were actually good friends, but they were very much on opposite sides of this philosophical divide. And they had this thing they would do. They would go around the country and go to college campuses, and they would argue about it and debate about it in a civil way in front of everybody.
And he'd say, what you do is you read the words. I say, okay, I read the words. Fine. And he'd say, but don't go and look what their purpose was. Don't go and look what the consequences are. I'm deciding this way or that way. Don't go and look at how does it fit within the values of the Constitution or other values that we hold. Don't look at, you see, just look at the words and read them. That's called textualism. And I say, I'll do that if you want, but I don't think I'll get very far. And he says, well, I say, for example, did George Washington know about the internet? No. So how does freedom of speech apply there? And you know what he would say? He'd say, I knew that. And then he would say, it isn't the problem of George Washington, the internet. It's the two campers. One camper is putting on his running shoes. Other says, what are you doing that for? He says, there's a bear in the camp. He says, but you can't outrun a bear. He says, yes, but I can outrun you. You see? And so he thinks that method, they make those textualists, and he was certainly one of them. They think they make some promises. Promise 1, we have a simpler way of doing it. Promise 2, if you talk our way, just read the words. The law will be similar across the country. Promise 3, Congress will love it because they'll know how their words are going to be interpreted in that statute. Promise 4, it will stop you or anyone else who is a judge from substituting what you think, or he thinks, or she thinks is good for what the law requires. And those 4 promises have made textualism or originalism in the case of the Constitution. So the words are very vague there. So he says in his books on this subject, he says, you go and look and interpret the Constitution's words to mean today what they meant to the average person when they were written. And I say 1789, 1787, yes, that's right. 1860 or 70, yes, that's right. Okay, that's what he wants. And now we have our promises, and they've made that system very popular. And I say, okay, please. That's what the book says. First, the book uses loads of examples. Why? What's my secret reason for using so many examples?
The devil's in the details.
No, that isn't the reason. It's very selfish, my reason. My selfish reason, those might be the real reasons, but the selfish reasons are because all the law professors think they know all this, the theory of it 30 times better than me. But I've had some experience they haven't had.
Yeah.
So I'm writing from that experience.
Okay, breaking in once again. So what's so interesting about the argument that Justice Breyer is laying out in the book is how much he relies on a actually much less easily explained approach, but he really has confidence in the complexity being a positive.
That's true. And he brings us an example to help us understand how the apparent simplicity of a textualist approach backfires in his view. It's a case from 2006 called Arlington Central School District Board of Education versus Murphy. The case revolved on whether a law permitted the reimbursement of certain fees, specifically fees for the parents who hired an education consultant when they sued the district. The law said it would pay for reasonable lawyer costs. So did that apply to an educational consultant as well?
So the Supreme Court ruled on that using a textualist approach that the consultant is not reimbursable under the law. Justice Breyer disagreed with that ruling. He felt it was too narrow a reading of a single simple word.
Now here's the magic word, right in the statute. You get your, ready? Costs, okay? That's the word, costs. So the woman in front of us had 11111. And she said, I would like my costs, and they include $29,000 for an educational expert. The school board said, you don't get that. You don't get that. This just means legal costs, and maybe just means filing fees. Okay. How do we decide that? Filing fees or educational experts? I say, oh, I see what you say, Nino. You said simple. Just read the word. Okay, I'll read the word. Ready? Costs. Okay, no, I didn't read it fairly to you. I should read it more carefully. I'll read it carefully. Okay, you ready? Costs. Or maybe I read it several times. Costs. And that was the easiest case I found. Say, they're tough. You're not going to get the end. It's famous French writer of the French Code, Portalis. He said, when the language is clear for a judge, you follow the language. But, he said, the language is never clear. And therefore, you have to look to other things. So I say, what do they used to look to? When I was in law school, or go back to the 18th century. Holmes, Brandeis, Cardoza, learned hand. You look to one of my former law clerks who became a legal historian. She said she found dozens of cases, or many cases, in the 18th century. What is the mischief that Congress was trying to cure? What was the purpose of this statute? What's the object? Or, if I decide this way, what will happen? That way, what will happen? Which is the better way in terms of this statute, given what they were trying to do? Or what are the values in that document, the Constitution, which I don't see my copy of here?
So you're describing the textualist approach as actually being newish. It's an innovation in the process.
I think it is pretty much.
Goes back how far? 30, 40 years?
Maybe, yeah.
What were the textualists reacting to?
What were they trying? I think?
Yeah.
I think they were reacting to the Warren Court.
Can you talk
so
about
if you'll say to the textualists, what do you agree with Brown versus Board of Education? They say, yes, of course. They thought segregation was terrible. But there were a lot of other things the Warren Court did on giving people, taking all the rights that are there in the Constitution, in the Bill of Rights, and applying most of them to the states. And there were a lot of other innovations they had, saying that you have a right under a case called Bivens, if a policeman interferes with your constitutional right to be sure that the search, if they made it of their house, they had cause, they have to have not used excessive force. All those things also began to apply across the country. Now, I don't think that was a bad thing, but they say maybe it was a good thing. And they don't either, but they might say whether it was good or bad should have been determined by Congress, not by the judges.
So what?
That's where it came from.
What sensibility was being offended in them by those activities?
The separation of powers.
Uh-huh.
They thought, to be fair to them, that what they thought was these are judges taking on too much power. And I say, no, first of all, it's traditional that you look to other things. Second, I think if judges want to go beyond what the law requires and substitute their own values of what they think is good for the country, no, they shouldn't. They're right about that. But I say that could happen. You have to control what you do. If you're sitting there as a judge, you can't jump out of your own skin, but you can try not to put your own prejudices or your own beliefs as a substitute for the law. And the risk that you won't, that's there. That's there whether you follow traditional methods, which is what I think and it's there if you follow these textualism or originalism as well. It's also there.
Okay, a little more guidance now on the conversation to come. Justice Breyer is about to use the word Dobbs. It's probably going to be clear from the context, but just in case it's not, when he says Dobbs, he is referring to the Supreme Court's landmark decision in 2022 that overturned another landmark case known as Roe. Roe was the case that guaranteed a woman's right to an abortion. Okay, back to the conversation.
Let's look at a case I really did dissent with others, but very strongly, was the abortion case, Dobbs. So we have our Mr. Textualism here. And let's say Mr. Textualism, Mr. Originalism, and they took the other side of Dobbs. They thought that they overturned Roe v. Wade, the abortion case. Okay. I say, now, why did you overturn Roe v. Wade? Why? Is it because Roe v. Wade did not use originalism? You know the answer to that is going to be no. Of course, that's not the reason. That can't be the reason. Because if the fact that a case of the Supreme Court, look at them all there, 90% of those don't use originalism. They're old cases. Look at the binding.
Because
here.
they predate originalism.
Yes.
Mm-hmm.
And so if you're overturning or threaten to overturn a case because it didn't use originalism, hey, what happened to the law? So I know he's not going to say because they didn't use originalism. That isn't why I voted, Mr. Textualism did, to overturn Roe v. Wade. I say, well, why did you vote to overturn Roe versus Wade? And the answer will be probably what they said in that case, because it's egregiously wrong. I say, well, I don't think it was egregiously wrong. Oh, but they think it was egregiously wrong. I say, oh, now I see. You're using this originalism because you are afraid that I will substitute my view of what's right or wrong for the law. But there's no fear of that with you, who are going to overturn those cases that you think are wrong? Of course, it's the same problem. So you see my point?
Yeah.
Yeah. The courts take time. That's one of their advantages. There are disadvantages, but that's one of their advantages. And they are on different time schedules than the political branches. And so they'll sit back and think about a case, and they'll try to see how the Constitution or other legal sources apply to it. Takes time. All right. Now, that difference makes a difference. Congress doesn't really, or only rarely cares what the courts think. Not only if it becomes a political issue, which it probably does sometimes, then they care, but they care about the political issue. And as far as the risk that you won't jump out of your own skin, but you'll try to be fair. You'll try to put your prejudices to the side.
Well, you're pretty optimistic, and you do believe that most justices are very sincere.
Oh, I do think that. I mean, that's my experience of 40 years in the courts. They do their best to decide the cases the way they think the law requires. I can't say all the time, but pretty much all the time. That's the job. They were put in the job by somebody possibly who had political motives. The President of the United States is in politics. The groups that go to the President are in politics. But once the person is appointed, at that point, he puts on that robe, and it's not politics anymore. He may have been appointed because he had certain views of what the law is like, but when he decides the case, according to how he thinks it should be decided, according to the way he thinks it is required that judges do decide things, well, he doesn't think he's been in politics.
And Supreme Court cases inevitably wade into very divisive issues, and this next case is one of those.
That's right. The case was called the New York State Rifle and Pistol Association, Inc. versus Bruen. And what this case said was that a law that limited concealed carry of a firearm was unconstitutional. And their decision to overturn this law was based on an argument that relied on historical standards of gun regulations that go back to the 18th and even the 17th centuries.
It's often the case that the opinions get longer the more the justices disagree. And in this case, Justice Breyer wrote a dissent that was 50 plus pages long.
Wow.
It's a bit long.
It was fascinating. Can you tell us a little bit, our audience, what went into play in that dissent?
Well, that was a case where the court was trying to decide whether gun regulation in certain states violated the Second Amendment. The Second Amendment says a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Keep and bear arms. But actually, a history professor, John up at Stanford, says that most interesting words in that amendment are not keep and bear arms. Most interesting words are free state. What did they have in mind by a free state, the framers? They argued about that. Mm-hmm. Is it a state that, well, in any case, that's a different argument. But I had been reading at that time a book of the history of the 100 Years' War written by a judge in England, Jonathan Sumptions, who used to be a historian. I knew the names of some of those weapons. So I put in the opinion. I said the majority has said to see if a weapon is protected by this here, it's the Second Amendment here. To see if it's protected by the Second Amendment, what we do is look to its history. We look to this weapon. Did it have protected ancestors in 1787? I said, what about a halberd? What about a skill ladder? What about Asian fire, where they used to throw over the walls to set the town on fire? I said, is that the ancestor of the bazooka? I mean, does anybody know? I mean, maybe somebody knows, but nobody the lawyers didn't know. I'll tell you that. They'll write some history, but so I said we're asking judges to decide a case they can't decide. They have no idea. And moreover, you're telling judges they should not look at the thing that I would think would be highly relevant. Highly relevant. What does it do to have all these guns around? And you can look and see that there are quite a few thousands, perhaps hundreds of thousands of people dead because all these guns were around, and quite a few of them should not be. So I said, look to things like that, and don't just look to what the word halberd or something, or one of these words meant in 1787. And there were other arguments in the case. I mean, the original case, Heller, John Stevens said, no, the purpose of this Second Amendment was that they were trying to get the Constitution ratified, and a lot of people were against ratifying it. And one of the arguments they used was read the first article of the Constitution. It gives Congress power. And one of the powers that it gives Congress is to call up the militias of the states and regulate them. And so one of the arguments the anti-constitutional people used is they'll call up those militia that just won the Revolutionary War and they'll disband it. And we won't have any protection. And Madison thought, no, I can deal with that argument. So he put in the Second Amendment, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Okay,
I just want to tell people who can't see you but only hear you that you've pulled out your pocket copy of the Constitution to read that amendment to us.
Yes. And so he said, you see, it says they can't do that. No, don't worry about that. Let's go into some of your other arguments. And he had enough refuge. All right. So Nino Scalia and John Stevens debated that historical point. Then we get to Bruen, and I make a few practical arguments. Like one, the judges won't know what a halberd is. And number two, so they won't be able to say honestly whether it is the ancestor protected of a pistol under your pillow or not. And also a very relevant argument, what will happen if we don't let these weapons being regulated? What will happen to people? The police who are killed, the family members, it's on and on and on. You will not be able to use that argument if we follow the majority here. And of course, I think it's a highly relevant argument.
What drew you to the law?
Oh, probably I was in a legal family. In those days, you sort of did what your parents suggested, perhaps. More than today, perhaps.
I have a circle of friends I went to college with, and I'm the only one of them who didn't become an attorney.
Oh, well.
And what I noticed about them from this time they started law school is they just loved the law. And I didn't know that was a thing, but they still do to this day, and it's been 40, 45 years.
Well, it's a very interesting profession. People think of going into it. I say, well, one thing is you can do a lot of different things. There are all kinds of different things because the country really rests in many, many public areas and business areas and all kinds of areas on law, but it also requires that you have both a head and a heart. Now, everybody has a heart, but you have to consider the interests of your client. You're trying to help some people, help him, help her, help some others. All that's part of it. And it also requires a head. And I'm not saying whether everyone has a head, but many do. So it's a very interesting.
Well, would you say you love the law?
No, I wouldn't say that. I'd say I think probably, though we didn't really discuss it when I grew up, what I do probably love, or at least I don't discuss it in that way, but I'm part of a community. That's what my father and mother, and that's probably what their example really taught. And that's what Derek Bach put in his book.
Can you remind people who Derek Bach is?
He was the president of Harvard, and he wrote a book about education with Bowen. And I think there's something like, he quoted from Pericles, the great funeral oration, probably 2,500 years ago or so, in Athens, which had something. It was democracy was beginning in Athens, not perfect, but it was beginning there. And the funeral oration, he said, one of the things he said, what do we say in Athens about the man who does not participate in public life? We do not say there is a man who minds his own business. We say there is a man who has no business here. You see? Part of a community. And find someone to love, you find a job you like, and you participate in public life in many ways. Voting, you can go into politics, you can be on the school board, you can be on the library commission, dozens of things you can do. But you help. You help others in your community by being part of it.
So as you can see, we talked a lot with Justice Breyer about his legal theory, but there was something else, Lia, that we were really interested in.
Basically, what's it like to wear the robes of a Supreme Court justice and to bear the responsibility of that power?
So we asked him to draw back the curtain for us on all of that.
I really also want to ask at a very, very just fascination level, what it's like to be you as a justice of the Supreme Court. And let's start with your first day there. Can you remember?
Yeah, you're frightened to death.
Tell us the story. Tell us about that.
No, the first day when I first appointed, my wife, Joanna, my wife is English, and we've been married for 57 years. We will this year. But her mother was not well. She was in England. And I'd been considered but not appointed the year before. And I was being considered by, you could tell from the news, the news reports. And they announced on I think it was on CNN, I think it was Bernie Shaw, or something. Or,
probably.
Yeah. And that the president was going to choose Judge Breyer from Boston. And then nothing happened. So Joanna called and said, anything happened? I said, no, nothing, probably not. And then my assistant, Marcia Bishop, came in and she said, the White House is calling, the president would like to speak to you. Well, that's a good sign. But you don't know what he's going to say. But when I heard his voice, I thought that was a good sign. And then I went home. The news, I think it was, what was it, ABC or something? They were walking by the door of the office, which I'd left open because I didn't want to close it. But he said, anything happening? Because Clinton had said, don't tell anybody till this afternoon because I want to call the others. So I walked by, and one of the reporters walked by. Is anything happening? I just went, I don't know. I sort of shrugged my shoulders. And I went home, and nobody was there because the children were coming back. But the whole little one-block street was filled with news trucks, so I didn't know how to talk to the news people. So I went inside, and there we are. That was what the first day was like of my nomination. Then I was confirmed, and then I went, oh, what is it like? Douglas thought it takes 5 years to get used to it. David Souter, good friend, he thought 3 years anyway. Because you think, oh, yeah, I could do this job. But then you get it. If you get the job, you'll think, oh, geez, I don't know.
Well, you don't know what is not being used to it?
What is not being used to it?
Yeah.
I think it was best put to me by the president. Said, he said, you will discover the applause dies away much faster than you think. And then you are left with the job. So you better like it. And you wonder, can I really do this job? And then you realize you just do your best. But you take seriously every case. Every case. That is the virtue of a job like that when you get older. You have to take it seriously. It means a lot. Even if it only affects 5 people, it means a lot to those people. And it's a hard job. You have to know what you read those briefs. In a typical case, we'll get 15 or 20 briefs on the 2 sides, maybe some more in some cases. And I don't know why they're called briefs. They're not very brief. No, they're not brief. But you read that and you listen to the arguments. And
so but you had those muscles already in place.
Different world. The Supreme Court is a little, there are things that are different about it.
What about?
Well, first, there are 9 people. You try 9 people. On the courts of appeals, they're usually, in a typical case, 3 people. With 3 of us, well, you're getting me talking an awful lot. I don't know. But it's different. 9 is hard. Try to get 9 people, 9 judges even, to decide where to go for lunch. I mean, not so easy. But you're also one of the branches of government. You feel that more. And so you're interested more in what will the results of this be.
Is there any case during your time that you feel should have been taken that was missed?
Well, the area that I wish the court had gone into more was the redistricting and drawing district lines. So some people on the court wrote, and that's what they said, they thought it's just not possible to turn this over to judges. And others thought, there might be ways. There might be ways to do it. And I think, maybe I'm just don't like the way it came out or was dissenting from that. But I think there are many different avenues which your object would be there, or mine would have been, to try to get the states to set up commissions to do the redistricting. I agree that judges aren't the best people to do it, but many states, in Britain, for example, other places, France, they do have commissions where they have several parties represented and others.
Talk a little bit about the process by which a majority opinion or a dissenting opinion comes together among multiple justices. Do you, as a case comes before you, do you sit and take a kind of poll of the room? Do you kick around ideas?
No, well, the first thing you do is, the first thing is which cases shall we take?
Right.
And the law clerks, we each have 4 law clerks, and most of them form a group where they divide. Say they're 40 or there may be in a year 5 or 6 or 7,000 cases asking us, please take it. We'll only take about 60 or 70, maybe 80. Okay, so somebody has to go through those briefs and summarize them, write memos, and I'll get a stack of memos pretty high every week, 100 or so, 150 maybe. I'll read through those, and it's easier than
those are from your clerks or from all of the clerks?
From all of the clerks. Uh-huh. And I have the briefs too, so I can go back to the briefs if I need to. But it's not as hard as you think, in almost always, to decide whether to take a case, because, for example, at least when I was there, I mean, is there a difference of opinion about what these words mean among the lower court judges? I don't have to decide who's right or who's wrong. I just have to decide, is there a difference of opinion? Or is there some special reason for taking a case? If a lower court judge holds the law of Congress unconstitutional, we'll probably take it. There can be other things, Guantanamo. But all right, the case is there. We hear the oral arguments in 2-week batches. First 2 weeks of October, November, December, January. Last 2 weeks, February, March, April. Okay? Each week that we hear a case, Monday, Tuesday, Wednesday, Monday, Tuesday, Wednesday, and it used to be 2 cases or sometimes 3 or 4, but probably half an hour each side. It's expanded a little bit, the oral argument now. All right. So, but that oral argument, before I go into oral argument, I've read the briefs. And I've divided them among my law clerks this time, and I have asked them to write memos on things that I'm not certain about, and I've read the memos, and then we all sit down and discuss them. Then I'm ready for an oral argument. So the oral argument where we're out there is not for the lawyers. It's for the judges. After all, if the lawyer wants to bring up some new point, why didn't he put it in his brief? So it is for the judges to have a chance to ask the lawyers things that are bothering them. So I think a good question is a question where I don't know the answer. I think the lawyer in front of me knows more about it than me. And if I can get him to talk about it, then I may learn something that will, in fact, help the case, help me decide the case. Okay? Now, a bad question is tell a joke, and I can't say I'm always free of that temptation. But
one thing I noticed in listening to those hearings is so often you and your colleagues interrupt with what seems like an impatience.
Oh, well, we used to interrupt more probably than they do now because it's a little longer. Because you want to get your question out.
It was a time issue then. That was
time
the issue.
Just time issue. The next day or the day after, say Friday, we'll be in the conference room alone, the 9 of us. And we're at a long table. And the first thing we do, we'll discuss the cases we just heard 2 days earlier or 3 days earlier. We each have a black book with the name of the case on the side and the space to write about what each of the judges think. And the rule is unwritten, the custom, nobody speaks twice till everybody's spoken once. And we proceed in order of seniority. That is to say, the Chief Justice says, the issue in this case is da-da-da. And I'm leaning this way. Everything's leaning to the last minute. But I'm leaning this way because, and I don't think the argument over here is as good because. That can be 5 minutes. It can be 10 minutes. He says what he thinks. You say what you think. And then it goes to Clarence Thomas, and then to me it did at the end, and then to Alito and Sotomayor and Kagan and Gorsuch and Kavanaugh and Amy Coney Barrett and Ketanji Brown Jackson now. Okay, nobody's spoken twice. Very good rule for any small group. And everybody said what they think. Then there's back and forth. Now, the same thing I tell the high school students, but boy, it's true. If you comment on what somebody else has said, and if the thrust of your comment really is, I have a better argument than you, ha, 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 that will get you nowhere. Because all it will do is it will lead the other person to think, no, I have a better argument than you. And that is no reason.
So it's very principled debate.
Yeah, you listen to what the other person's saying. Where are they coming from? And can you add to that? Or can you help show how it can be brought together with what somebody else is saying? And that kind of argument can work.
So it's highly collegial.
Yeah, it's professional. It's very professional. I have never heard a voice raised in anger in that room, no matter how controversial the case. I've never heard one judge criticize another as insult another, not even as a joke. We have our books to write things down. It's very professional. And at the end of that discussion of the case, 40% or so are unanimous, but there are maybe 5, 10, 15, 20% in a year could be where they're not, where it's 4-3 or it used to be 5-4. And then the chief assigns the opinion to be written. But he's restricted as to how he can assign it. First, everybody writes 1 before anybody 2. So you assign, everybody gets 1, and then 2, and then 3, and that keeps it fair in terms of numbers anyway. And then I was 9th. I was the last one to speak because I was the junior for 11 years. I almost held the record. I missed the record by 12 days. I thought of writing to Alito and saying, could you possibly hold off being sworn in for 12 days so I could go down in history as the answer to a trivia question? But I was last. It was 4-4. Now, you see, I can say 3 words and they have to assign it to me. They have to. The chief has to assign it to me. And the 3 words are, I'm not sure. See, at that point, he has to, because he wants 5. Because people are really not so interested in what is the law according to Scalia or Breyer or O'Connor or anybody else. They want to know what the court thinks. So you want desperately to get 5 people at least, if not 9. all right? And so you're going to, but the chief assigns it. And if it's assigned to me, I put my law clerks to work, whoever was on this, and maybe she'll write a draft long, and I'll get that. And I was a law professor, so when you turn a draft over to a law professor, first thing he does, puts it in the word processor now, and you change the first word. Well, you change the first word, you have to change the second word. And then you change the third word. And before you know it, you have a new draft, and I give it back to the law clerk, and she thinks hers was better, but there we are. And so then we go back and forth. Then we circulate it finally, and hope I get a memo from others, which have 3 words on that memo. No, only 2 words. 2 words. I want to see the words "I join." So, and it doesn't have to say this is the greatest thing since sliced bread. That's ridiculous. I want to see "I join." And most of them will usually, they might say, "I join if." Or they might say, "I join, and would you consider?" And so there's suggestions, and you work things out and try, and then you can write a dissent. You can write, somebody else can write a concurrence. They can write what they want. Finally, everybody's written or joined something that was written, and the opinion comes out. Now you understand the whole system.
Can I take it back 2 steps? The day you sit in the conference room and you take on the cases, and one by one everybody gets to talk once, and is any part of that an attempt to persuade one another?
Yes, of course.
And have you been persuadable from a position?
I would hope so.
Yeah,
and I would hope so. Sometimes wrongly, but
so. And how long does that go on?
Usually a couple of hours. You're considering 4 cases.
And the issues that we were discussing at the beginning of the conversation about whether a textualist approach makes sense or not in a particular case, would you have those conversations then about, well, the text says, and well, the text doesn't matter?
Yeah, to a degree. I mean, it wouldn't be too philosophical. You're applying it to the particular case. And somebody says, well, look at what the text says. And somebody else might say, well, yeah, it does, but look at what the purpose was. And I'd say sometimes if I'm writing that, and I know some people just want to follow the text, and I see the legislative history points to a different purpose, I might say for those who accept legislative history or purposes and so forth, look at this.
It seems the word negotiation does not capture what's happening around that table.
No, it's listening. It's listening and trying to get people together. And why I go into this when I'm talking to the 7th grade or the high school is that's what I say I want them to do. Don't talk to people who agree with you all the time. You don't like what's going on in this area or that area, talk to somebody who disagrees with you.
Mm-hmm. The book is definitely an attempt to persuade.
I think that doesn't work.
What are the stakes right now?
Well, I don't think they can keep this system of. You can't be a really tough textualist because you saw the example of costs. Well, there are others that are much worse. So I think it does help. And if the textualists will point to examples where looking into what Congress wanted is very hard to do because they wanted different things. And I understand that. But maybe it isn't hard to do. And in the case of costs, maybe they said what they wanted to do. Or maybe there were reports that told you, and maybe nobody disagreed. And there are all kinds of cases where it isn't so hard to do. So use it when you can. And if you're going to decide this way rather than that way, and it's going to lead to a disaster, and the agency will never be able to pay the hospitals, take that into account. And maybe that's a suggestion that your interpretation is wrong. Mm-hmm. You say, so you use these tools, and Holmes is the one who said this. How do you know which one to use in a case? Well, that's where experience or instinct or learning how to be a judge over time, it helps. You don't know what's going to happen in the future in many areas. And there will be application or non-application 30, 40, 50 years from now. And you have to figure out, well, what were they trying to deal with? And given what they're trying to deal with, and given the words over here, and given the likely results, and given the political arguments of those times, and given how things are changed, well, all that comes in a difficult case. And those cases in the Supreme Court are pretty difficult.
How important is it when you're writing an opinion or the majority view or dissent, that in the end, the public understands your argument?
It depends on the case. But if, for example, you're writing a bankruptcy case, you want to be sure the bankruptcy bar understands it. If you're writing a habeas corpus case, you want to be sure the criminal law bar understands it.
Different
and if
audiences.
it's a big issue that people are interested in the country, you better write pretty clearly, and you better write simply. And if you have to decide something in a way that seems, say, for example, that the criminal law will not punish people who've done something wrong, or vice versa, if that's what you have to do because that's the way the thing is written and so forth, you better explain why you decided that way so that the average person can understand it. I think writing clearly in cases, all you read in the papers, and you read the case's results if the case has political content, and it might, even if the judge wasn't doing it politically. If the case has some social content, and therefore the readers of the average newspaper will be interested, that might only be 30 or 40% of the cases, or less. But they're not going to read. One of I think was my most difficult case. It was a case called Google versus Oracle. I had to learn the Java language. When I started out, I thought Java was an island somewhere, but we had to do that. And it took 2 years. And the thing I was pleased about it is that at the end, I looked at a little bit of what the commentators were saying, and they said, well, we got the issue right. Whether they thought we got the result right or not, that's a different question. But did we learn enough to understand the case?
Do you feel that your approach, purpose-oriented as opposed to textual-oriented, will be more successful at helping the average person to understand why the court is making decisions that it's making?
Yes. Yes, I mean, see, law is trying to be helpful. We have 330 million people. They have to live together. There's every race, every religion, every point of view. My mother used to say there's no point of view so crazy there isn't somebody in this country who doesn't hold it. and they have to interpretations in the longer run that help bring people together, living together, cooperating productively. Good. And you go the other way and just say, I don't know what'll happen. I don't think it'll be good. So I think they won't. Pretty soon they'll come up against a case, and they do. Textualism doesn't work too well, so they won't say they're not doing textualism, but I think they won't.
You said to Lia a few minutes ago that you feel that textualism will be proven less effective than its proponents say, and therefore its time will pass.
Yes.
But we don't seem to be in that time now.
Oh, well, I think if you have a case, as we did recently have, where you have in the majority 5 people, all of whom say they're textualists, but they all write a separate opinion, why did they all write a separate opinion? Mm-hmm. So I said, maybe they're not. And the lead opinion in that case say, well, textualism really is seeing what the point of the statute is. Well, I say that's what I do, okay? So there are many different ways.
So they may call it the same thing.
Yes.
And apply it in a different way.
Right.
So you're an optimist about all of this?
Mildly, but that's where Senator Kennedy would tell his staff, one, do not be interested in credit. If the thing works you're involved in, there'll be plenty of credit. And if it doesn't work, who wants the credit? But he'd also tell us, if you're having trouble, we can't get through this bill, we're trying to stop something, find a person who genuinely is intelligent and is against you. Maybe from somebody else's staff, and sit down and talk to that person. Wait, don't talk too much. Listen. And eventually that person will say something that you really agree with. And at that point you say, good point that you made. Maybe we can work with that. And quite a lot of the time you'll get 30 or 40% of what you want. Good, take it. Don't hold out for 100% of nothing, where your followers say how wonderful you are. No, you want results. And so now, when I tell that to the high school students, or I tell younger people and so forth, what interests me is they're not looking out the window anymore. Actually, they're interested. And it's their interest in trying to be helpful, in holding the country together, in cooperating, their interest in finding ways of doing that makes me a little bit optimistic.
Well, making the case for listening you're ringing our bell. It's what we argue for as well at
also
Open to Debate.
We're the opponents that you seek out in the process. It's all part of what we do.
What a perfect place to finish. Justice Breyer, thank you so much for joining us.
Thank you.
And a big thank you to you, the audience, for tuning into this episode of Open to Debate.
As a nonprofit working to combat extreme polarization through civil debate, our work is made possible by listeners like you and by the Rosencrantz Foundation and by supporters of Open to Debate.
Robert Rosencrantz is our chairman. Our CEO is Clay O'Connor. I'm Lia Matthow, Chief Content Officer.
Elizabeth Kitzenberg is our Chief Advancement Officer. Andrew Lipson is Head of Production. Michelle Debrasini is our Director of Marketing.
This episode was produced by Alexis Pancrazi and Marlette Sandoval. Editorial and research by Gabriella Mayer. Max Fulton and Julia Sirkin provided production support.
The Open to Debate team also includes Annalisa Cochran, Gabrielle Iannicelli, Rachel Kemp, Eric Gross, Linda Lee, Mary Regis, and Tom Bunting.
Damon Whittemore mixed this episode. Our theme music is by Alex Clement.
And on behalf of Lia, I want to say thank you to all of you, and I'm John Donvan. We'll see you next time.